You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
Welcome back, members of the jury. I'm so thrilled to have you tuning in to a new episode of the podcast. This season, we're diving deep into a cornerstone of our justice system, due process. In this season's episodes, and today in particular, we'll be exploring why due process is not just a legal concept, but a fundamental right that protects every person in America that is charged with a crime. Today, we're going to hear from a trial attorney themselves who took his client's due process right all the way to a jury trial so that his client could have their day in court. We're going to learn about the case and uncover the intricate workings of the courts. Now, whether you're a law enthusiast or simply curious as to how justice is served, this season and this episode promises to be both enlightening and thought-provoking. I'm so excited to be able to interview this attorney today because this is the story of his first ever trial, and it is a doozy. So I'm so excited to get into it. Thank you so much for joining us today. Deputy Public Defender Carlos, please introduce yourself to the members of the jury.
Yeah, happy to be here. I am a deputy public defender. I'm a trial attorney. I currently do all misdemeanors. I'm expected to do some felonies coming up soon, but my practice for the last few years has been all misdemeanor cases. I mean, there's a wide spectrum of different misdemeanors, domestic violence, DUI, some sex cases, petty theft, things of that sort, but mainly DUI. And the case that Lucas has mentioned is a DUI, and we can get into that whenever you like, Lucas.
Yeah. Before we do get into it, I want to get the audience an opportunity to learn a little bit more about you. Can you explain to us how it is you got to become a public defender? Was that something you always desired to be?
For a while, because when I was young, my uncle, he was a public defender. I spent a lot of time with him, and he would tell me his kind of war stories, and I kind of looked up to him. So going to college, I knew, I want to go to law school. I want to do public defense. And then I got into law school. I did clinics that were criminal defense oriented. And then I went and interned at a few PD offices here in California, different counties.
I love asking that question because every time I get the complete opposite answer as to why someone is living the life of a public defender and what people, the public, and oftentimes our clients think it is how we got to be a public defender. And, time and time again with the guest on this podcast, it's, it comes from a desire of that attorney for the right that all persons are awarded an attorney and their day in court, and it shouldn't just be left to the wealthy. And I don't know if it was Hollywood or a stigma, but I love that question and starting off the episode that way because I think time and time again it disproves the stereotype of what it means to be a public defender and what type of attorneys are working this job. And it's not those that couldn't get jobs anyplace else or who are just trying to get a check. It's for the true social justice warriors and honestly, the ones who believe the most in the Constitution. So I really appreciate you sharing that story, and the fact that it's like a generational thing for your family is amazing. Well, let's get a little bit into this case. Let me know, when you got the case assigned, was this one that you immediately saw that there were tribal issues with that needed to be addressed, or walk us through how we ultimately got to the box for this case and break down the charges?
Sure. So I got this case assigned. It was a no time waiver case. I didn't arraign the client, so I didn't meet him till the first readiness. I spoke with him on the phone before. I went over my case review with him. He was charged with 2 counts, as in, all alcohol DUIs are usually charged. Driving while under the influence of alcohol, and then driving while having a measurable blood alcohol level of a 0.08% or more. Also, this particular portion of the county was known for charging what's called a refusal allegation. So they're alleging that after being arrested for a DUI, that my client refused to submit to a chemical test, whether that be a breath test, a blood test, things of that nature, after being arrested. And that's something that he'd be required to do. So that's what he was charged with. I didn't speak with him at arraignment. I spoke with him before the first, what's called a readiness conference. Namely, that's a hearing where we kind of update the court with what we're doing. Are we settling this case? Are we continuing for negotiations, continuing for investigation, or are we just going to go forward with the trial date? And in this case, when I spoke to my client had told me, you know what, I had seen the case as, this is pretty bad case. The facts were that my client was in the number 2 lane of the freeway, parked, stationary, not moving, that there were 911 calls, about 911 calls from just concerned drivers about a person in a vehicle in the freeway asleep in the driver's seat. And I told him this. I'm like, hey, this doesn't look good. But from day one, my client was, you know what? I wasn't driving that day. I wasn't the driver. I was in the vehicle, but I wasn't the driver. So I was like, this is simple. Okay. We're not negotiating because one of the things that, if you're pleading guilty to the DUI, you are admitting that you drove a vehicle while under the influence of alcohol or with a blood alcohol level of a 0.08. He's not admitting that. So we go forward with a no time waiver trial. And I'm not too sure, Lucas, people that follow your podcast are familiar with what's a no time waiver. But I'll explain it, that you have a right to a trial within 30 days of your arraignment if you are in custody at your first hearing, or within 45 days of your arraignment if you are out of custody. So this client was out of custody at his first hearing, and we confirmed the speedy trial date, within 45 days of that first court hearing.
Well, I want to pick your brain into about that, because oftentimes out of custodies, they generally like to waive time so that, they're not really under the thumb of the criminal justice system. And it's a lot of work to honestly do a no time waiver trial. What was going through your thoughts as, this being your first trial that you're going into and being under the gun of that no time waiver status?
Yeah, there's a lot of things going on, just because as a misdemeanor attorney in public defense, you are carrying a caseload of upwards of 100 cases. So, you're balancing all of your active cases, motions that you need to write, clients that you need to talk to, people that you need to go see in custody, with somebody that doesn't want to waive time. They want a speedy trial, and you need to prepare in a short timeline, cross-examination, any potential direct closing arguments, opening statements, motions, pretrial motions, which are called motions in limine, asking the court to admit evidence, asking the court to exclude evidence, certain pieces of testimony, certain prior convictions. Those are all things that you need to prepare at the same time of having this, 100 other cases on your desk. So it is difficult. It's tough, but I think this one was a bit more simple, just because we knew what the argument of the case was going to be. DUIs are pretty routine. You're going to get an officer. You're going to get maybe a witness. Aside from the officer that saw the driving pattern, you're going to get a phlebotomist or somebody to testify to maybe if there was a breath test, to the calibrations of those breath machines. And then you're going to get a criminalist to testify as to, namely, their opinion as to whether your client was under the influence at the time of driving. So they're going to work back from the breath sample or blood sample that was taken usually after driving, work back and opine as to whether your client was under the influence at the time of driving and what their blood alcohol level might have looked like. So usually that's a standard DUI, but with a no drive, but when I'm saying no drive, my client's asserting that he wasn't the driver or he wasn't driving the vehicle. It's simple. We're just arguing, sure, he's under the influence, his blood alcohol level is through the roof, but he wasn't the driver. And I think that made this trial a little bit more simple or more easy to prepare for.
Was there anything that you found to be challenging or surprising as you prepared for this first DUI trial?
I would say challenging in the sense that I mean, it on the face, this looks like a terrible DUI, right? It looks like, jurors are not going to like the evidence. It looks like the judge is not going to like the evidence. We have a high blood alcohol level taken 2 hours after driving. We have him parked in the middle of the freeway. Well, not parked, but stationary in the middle of the freeway. And it just doesn't look good on the surface. And, one thing you have to advise your client of is the max consequences if they were to be found guilty. You need to talk to them about realistic outcomes if they're to be found guilty. And I think, I was still a new attorney. Custody is kind of a big thing when you're new because a lot of the cases are not that serious. So when somebody's going to go into custody, it is a bit more serious. And, I think that was one thing that was challenging. I have to have this conversation with my client like, look, man, this is not a good DUI. If you go down, namely if you're found guilty, you should be prepared or at least, yeah, prepared to go into custody. Further, on top of that, the allegation under the refusal allegation, if that's found true, if there is a guilty verdict, it requires that your client go into custody. So I think that was something kind of new that I do. Obviously, I had only one prior trial, but also just having that talk with client, like, hey, man, there's maybe a good chance that you would go into custody if we lose this case. So I thought that was something that I hadn't done before.
Yeah, and I don't think that ever goes away because that's unfortunately one of just the potential consequences of the criminal justice system. But that's your role. Lay out the options on the table and help guide your clients into making the right decision. So, and it only gets better with time and the more that you do it. And so that's fantastic. So I want to actually now get us into, we've prepared for the case. We've had the appropriate conversations and investigations. We get assigned to the trial department. One of the first phase of the trial are motions in limine. In this case, were there any motions in limine that ended up playing a significant factor into how the case ultimately played out?
I would say no, namely because there wasn't much that we were trying to exclude. We were actually okay with the state of the evidence as it was, knowing that we had a defense up our sleeve that the DA or the prosecutor wasn't aware of. Just because it was a no drive, it was my client had told me in confidence his side of the story. So that was kind of something we had up our sleeve. We had the standard, excluding maybe any priors that my client had, trying to just kind of throw some curveballs at the DA, trying to get some of their experts' testimony excluded.
That's what I was going to ask. I know you were saying that you weren't challenging the science in a DUI case, which is definitely the preferable defenses because it's really hard to go against machines and calculations. And so knowing that you weren't really, it didn't really matter what any of the science was because that wasn't the element that you were attacking. You still attempted to address some of the scientific evidence that the government likes to introduce during DUI trials?
Yeah, absolutely. I mean, it wasn't a make or break us as in maybe some other cases, honestly, where you really are, going to combat that science. But we still fought it. It's their case. They got to prove it. And, you don't make it easy for the DA ever. So I think, throwing something like that at them, even knowing that we're not going down that route, was something that we did just to kind of throw a wrench in the machine.
I think that it's appropriate too because, I've done my fair share of DUIs, but definitely have observed more than I've done. And, I think one of the things that they try to do oftentimes is a tactic of what I believe to be lowering their standard of proof because, the law is 0.08, yet they hire these experts that try to suggest impairment starts at a lower level and that therefore that should help do it. And I hate that because that's not the law. And here it is, your government, the people who wrote the law who are now trying to, simultaneously subvert it with the guise of a paid I'm doing air quotes for the audio listeners, experts that are saying, of course, impairment starts at a little lower rate. But I think if that was truly what the science said, that's what the statute would then be to follow. So kudos to you. I guess going into those, were there any favorable rulings that you ultimately got during the in limine process?
Yeah, I mean, just clients' priors. I don't remember exactly what they were, but I know there was like There was like some sketchy priors that we wanted to get out, and I just remember that. I mean, those were granted. Usually, when the priors are pretty old, they're going to be excluded. So the judge ruled in our favor, got those excluded. So we were kind of gun ho on him going up and testifying, knowing that those aren't going to be, or he's not going to be questioned about those. So that was favorable. But either way, the other ones that did not get granted in our favor, obviously the judge is going to let the expert kind of run wild. Really, it didn't matter in this case.
And that's got to feel good too, to really know that
Yeah.
at the end of the day. Okay. And now I think you've like kind of hinted at and done a little sprinkling of the facts of this case, with a 2-count DUI. And because some calls were to the police about an individual who appeared to be sleeping in the car. Now I want you to do is, take us to what the prosecutor's point of view is. In their opening statement, what is their message to the jury about what the evidence is going to be from the government stance?
Sure. They're gun ho. This is a slam dunk DUI. Guy's in the driver's seat, on the freeway, and his blood alcohol level was through the roof 2 hours later. So he's already eliminated 2 hours worth of alcohol. Namely, every time you consume alcohol, your body's always working to eliminate. So they're saying, his blood alcohol level was higher than what it was at the time of the blood draw, and it was already high. So a prosecutor goes up. This is a slam dunk case. He's in the driver's seat. We have, 911 callers. We have the officer who conducted the DUI investigation. We have the phlebotomist who did a proper blood draw. We have a criminalist that's going to testify as to, how even it was higher his blood alcohol level was at the time of driving. This is a slam dunk. And then also, too, this is something that prosecutors always do, especially in DUIs, but I see it all across different charges, is that how dangerous this is, right? How dangerous this conduct is. They're trying to, and I don't like that because that, I think it's improper. They're trying to invoke emotions of the jurors that is not something they should be considering, right? Danger to the community is not, at least for DUI, I'm not too sure about, I haven't come across a charge that really that should be in consideration. It should be a consideration whether the prosecutor has met their elements, right? Was this person driving? Was this person under the influence at the time of driving? But we did see that from the prosecutor throughout this whole case, especially in opening. This is dangerous. This is dangerous conduct. And that's why more so you should find this guy guilty.
It always amazes me how they can. Did they actually use the word slam dunk?
No, that's my own feeling of it.
I'm like, I get what you're saying, and I'd be surprised if they did, but like again, like just hearing that, and it's like again, if that's all you would hear, of course, you're gonna feel some type of way, but this is why I love what we're about to do, because we're about to show them the importance of due process, and just because a police officer, innocent, no motive to lie against completely innocent bystander, and the government prosecution office, they can do everything right. They can do everything in good faith, and they can still be wrong, okay? Because they are not the decider of facts as to when and when not a law is broken. That is the community. That is the jury process. And, again, like that's what's going on currently, is the government and the administrations, they're throwing out a lot of allegations, and that's all they are. And the importance of due process is you get to air those out. And so, take us to that, utilizing the due process of your client. In this case, you got a chance to finally in court in front of the fact finders of the jury respond. What was it in your opening statement that you highlighted to show, there's another lens in which to look at these facts?
One thing I will note, I did have assistance on this case. At the time, we had what's called post bars. So a post bar is kind of like an intern that has graduated law school, has taken the bar exam, but they are waiting on their bar exam results. So I had a person that was in that position assist me on the case. I filled this person in with our defense, our theme, theory, and this person actually did the opening, but namely kind of just opened that, not too strong, didn't get into our defense necessarily. Well, at least the specifics, yeah, because it wasn't in evidence, and we don't want to tip off the prosecutor. But we kind of just let them on, what they got to prove driving under the influence, and that's something that they won't be able to prove going forward.
So you elected to the strategy of keeping the fact that your client would be telling his side of events in the back pocket and not give the jury that heads up.
We alluded to it, like, right, our theme was drunk but not driving. And I think we kind of set the stage for that no drive defense, but at no point, and this will come up a little later, did anybody know that we were gonna that somebody else was driving? Um, and I think that later, we can talk about it later as we go through the process of the trial. But that's something that I think blindsided, everybody, and especially the prosecutor. And that's something that we saw later in the trial after the people had arrested.
Okay, and now, so then obviously the openings are completed, and we go into the government's case in chief where they start calling their witnesses. And, as you alluded to, specifically as it related to the science, they're going to have somebody who did the breath test or blood taking, and they're going to have an expert to do retrograde extrapolation. Knowing what we know because of your insight, we don't really need to focus a lot of time on those. What I'm interested, though, is from their point of view, and while you're watching them put on their case in chief, what evidence did you feel that they were relying on to make the connection that your client was the driver?
Yeah. So, they had two things, right? So they had a 911 dispatcher come in and testify about how 911 calls are recorded, or how they're recorded, maintained, and stored for maybe trials, and how long they're stored for. That person came in and authenticated, namely, 5 of the 911 calls. And those 911 calls talked about a driver or a person. Well, they would say the driver in the driver's seat of a vehicle that's not moving. And one key point or cross-examination of this person was just highlighting the fact that none of those people saw the vehicle move at any point. A person kind of fought me back on it. They're kind of being a little like, it's obvious they're the driver, right? But I made sure to highlight, like, look, these people are calling, and when they're calling, that vehicle is not moving. This person is asleep in the car, and that vehicle is not moving. So that's the first kind of thing that we're kind of attacking when the people open up the case. And the second, probably the biggest one, is the CHP officer that came on and did his investigation, because there were some holes that he left and some things that he said that I think helped our case in the long run.
And, one of the things I do know from DUI trial work is timelines are super important to one of the issues you're highlighting with regards to when was the car ever seen moving, because that is a required element in our state in order to convict of a DUI. And, what was assuming our clients speak to the cops, because everybody loves to lie to the police and DUI interrogations about their drinking patterns and their drinking amounts. And so that also gives us a timetable. Now, in this case, well, obviously we're not really worried about that. Did your client give any statement to the police regarding any kind of timeline as to how the car got there, if he had drank, what that was looking like? One of the times that's our biggest enemy is our client statements. Was that utilized in this case?
Yes, and that's actually something I tried to get excluded. That was denied. That was probably the biggest thing that I forgot about when we talked about motions earlier. Try to get statements out, excluded under a few different avenues, and the judge let those in. Anyways, he gave statements to the police, and I was very kind of nitpicky about these statements because, on surface, they are inculpatory. They tend to show that my client is guilty. But when you dive into it, it kind of goes with our story that's later to be told. So the biggest thing from the officer is that, well, first he writes his report and about, including the things that he initially saw. And then later he gives 2 weeks before trial, he gives another statement to the DA's office or to the prosecutor with new facts. And that's something as defense attorneys we kind of pick at, just because time's elapsed. These people are still working as law enforcement, officers. They're doing, continuing to do arrests or continuing to do investigations. So they're working, they're doing other different cases. And as time elapses, your memory fades. So it's kind of tricky when you come, months or maybe even years later, and you give a new statement that, is different than what you said back when you actually wrote the report about a day after you saw those things. And one of the things, well, there was a few things, but one things that I picked out was in his report. There's two questions: where were you going, and where were you coming from? And my client says I was going home, and I was coming from work. And that's one piece of evidence that the prosecutor said, look, clearly he's the driver. He told the officer, I'm going home and I'm coming from work. And what I did, is I highlighted that, look, that's different than saying I'm driving home, I'm driving from work. Because it'll come in later. Client's going to assert that he's not the driver. So that's consistent telling the officer, look, I'm heading this way. I'm coming from this way. That's different. And that's something that I highlighted. That's different than saying I'm driving this way, and I'm driving from this way, which would be an admission of that element, namely that you drove the vehicle. And that's something that, I was able to get out of the officer. That's different. And it's a different answer. And that's something he didn't follow up on. And it's a mistake of him because he just made the assumption and didn't ask further questions, which, if he did, could have harmed our case a bit more.
Now, one of the things that I'm interested in, especially with a case that is out of California, that where a client's statement is controversial. Was there any type of language barrier that then took place and potential misinterpretations of what was also being conveyed?
No, in this case, there wasn't. In this case, I mean, other cases, definitely, there's definitely a barrier that, where clients seemingly give more incriminating statements, but they just don't understand the questions. But in this case, no, my client understood the questions, he understood English perfectly. There was no language barrier. But the issue in this case was just that the question was not specific. The question was kind of vague. Where are you going? Where are you coming from? And that doesn't necessarily mean that this person's driving a vehicle.
I love that. Okay. So the prosecution gets through their case in chief. Was there any, at the conclusion, is there any visual evidence by way of pictures or body worn camera that they entered into evidence or try to rely on?
No, in this case, because it was CHP, and I think CHP is kind of moving in a different direction now, but from my practice, CHP has always recorded their investigations through what's called MVARs, the mobile vehicle audio and recording system, something like that. Short, we call it MVARs. Their investigations are recorded by this dash cam footage, this dash cam camera that records everything that's in front of the vehicle. It also records your client in the back of the vehicle when they're arrested. So given that it was an MVARs case, it was a CHP case, we almost couldn't see any of this conversation between the officer and my client. That's kind of natural. That's normal with CHP cases because their patrol car is parked somewhere behind the client's car, or off to the side, pointing in a different direction, and they generally don't capture any in the investigation. May or may not have been helpful for our case. There might have been things that corroborated, what my client was saying. There might have been things that, kind of showed that he's not being truthful, so you never know what footage is going to show. But in this case, it didn't show anything. That's why none of it was admitted.
Got it. Okay. Well, that takes us to the halfway point of the trial, and kind of like to use that as like a little intermission in the podcast, and just remind the audience that if you're really enjoying what Carlos is telling us and you look forward to future stories of successful attorneys in the courtroom and the importance of due process, then please subscribe to the podcast on your favorite podcast listening service, whether that be Spotify or Apple Podcasts. You can also find us on social media. Most of our handles are at Members of the Jury on all platforms. And if you want to be a guest or know anybody who has an amazing story, please have them reach out to me at LHIRSTY at membersofthejurypod.com. So, Carlos, we're getting into the exciting part, a defense who has a case in chief to put. Now, you have alluded, as you mentioned to in the opening statement, that, one of the witnesses was going to be your client. Aside from your client, was there any other witnesses or visual evidence that you were relying on and planning on introducing through your case in chief?
So no, and that was kind of a point of contention as my client testified um, between the prosecutor and myself. Prosecutor was upset. Prosecutor had a supervisor working on the case with him, so it was kind of a two-man team over there. And then I have my intern working with me, but it was just my client. Prosecutor later, I mean, we can go into it later. I don't know if you want to get into it now, but namely, my client is asserting that somebody else was driving the vehicle, and later the prosecutor, because of that, accused us of violating 1054, Penal Code Section 1054, which we can flesh out a little bit more, but
Yeah, no, I'm happy to. I mean, basically, from what you're trying to say was I guess they were trying to argue that there was a discovery violation because in affirmative defenses of third party culpability, there is a requirement to that. But I guess my questions for you, and I would love for you to expand on this, was it so much here's the name and identity of the third person, or just simply like, look, I'm telling y'all I wasn't the driver, and just kind of denying that element?
yeah. So client went up there. He testified, hey, my buddy Caesar was actually driving that day. We had drank the night before. We had partied, blah, 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 blah. I got so drunk and I had to work the next day. So client starts throwing out this name Caesar. That's never been said before. It's not told to the officers. And Caesar was a driver. Caesar's his friend. Um, Caesar had driven him from work. They had worked that morning. Caesar was driver because he was too drunk to drive. And Caesar was driving them home when the vehicle stopped. Caesar goes to get gas because the vehicle had broken down or whatever. And that's when the police officers approach him. Prosecutor says, that's, hey, defense violated 1054. Namely, I think there's a subsection A2 or whatever that says that defense must disclose any real evidence to the prosecutor. But my argument, and I think this is, I don't think this is wrong, is that any defense, just because it's a defense, doesn't mean that we have to disclose it. We never, I mean, as defense attorneys, we don't ever have to disclose our defense. Caesar was not a witness I intended to call. And if he was, then I would need to disclose his full name and address. But Caesar was not on a witness list. And thus, it was my position that, I complied with my discovery obligations.
And ultimately, was that evidence permittable? Did the judge let that evidence in?
Judge let it in. Judge found there was
Okay.
no violation of 1054. So client went up and testified about, namely, that Caesar was the driver. Caesar had been driving them all day. Even though Caesar was not there, Caesar had walked off the freeway to go get to a gas station and had not come back because, whatever, the gas station was far. Client ends up in the driver's seat because
That's what I was just about to ask.
yeah. So to explain that, I had to walk him through, like, how did you end up in the driver's seat? If you're not the driver, how did you end up in the driver's seat? And he says, you know what? There were some citizens that stopped at some point. They had knocked on the window and said, hey, man, you're in the middle of traffic. You need to move the car. So he jumps into the driver's seat and attempts to move the car, but the car won't start. The car is busted down, won't move. And then he says he knocks out, falls asleep in the driver's seat. And then he wakes up to CHP officer. And that's when the DUI investigation starts. And that's why he's found in the driver's seat. He tried to move the car wouldn't move, falls asleep because he's just so drunk and so tired from working. That's what happened.
Well, no, I love that. I mean, that's again, I'm going to be a broken record all season, but like that's what due process is. Like, basically, this man had the opportunity. He exercised his right to remain silent during the incrimination phase, but then waived that right to then provide his due process in a court of law, have his day in court, and tell his side of the story. And that was it. That was your evidence, right? No other witnesses, no other visuals that were submitted.
No other evidence, no other visuals, nothing. Just client giving his side of the story, telling the jurors that, hey, I wasn't driving that day.
Love that. So then we go to closings. I'm assuming the prosecution just rely on their opening and then say that, no one ever heard their story before. It's self-serving. Therefore, it's not believable. You get up there and in your closing, you say what?
So I attack in two ways, right? I first go at the state of the people's case. I say, look, this is insufficient evidence to prove element number one of any DUI, count one, count two, that my client was driving the vehicle. And then, as you stated earlier, in California, there is what's called a California CalCrim, which is an instruction to the jurors explaining the definition of what it means to drive in California. So there needs to be, I mean, I forget the exact language, but it's like actual physical control, moving the vehicle even in the slightest way. There has to be movement of the vehicle. So some people in California, or just everywhere, just in California, that you can get a DUI with your keys in ignition, and that's not necessarily true. Maybe it could be circumstantial evidence, as in this case, that the person was driving, but there needs to be proof of actual physical movement by the person to establish that this person drove a vehicle. And that's something that I at first in my closing attack. Look, we have statements from the officer that are based on assumptions. Where are you going? Where are you coming from? That's not an admission of driving. The prosecution was, harping on this. Look, he admits to driving. And I said, look, that's not enough. That's not the same thing as saying I was driving to work or to home from work. I was going home from work, and he was doing that by means of Caesar. So, my first part was, look, prosecution has failed to meet the burden of proving element number one. Element number two, you can see. This guy is under the influence. This guy is definitely above a point .8, not an issue in this case. But in this case, the prosecution has failed to meet their burden of proving beyond a reasonable doubt that he moved that vehicle at any point. We didn't see that from the 911 dispatcher when those 911 calls in. All five played. The judge excluded four of them because there was nine. And none of them, none of those callers said anything about that vehicle moving at any point. Officer came in. He never saw the vehicle move at any point. My client moved the vehicle at least. And he just had those statements that he assumed my client was driver. And then the second part of my closing was, look, it's not on us to prove anything in this case, but we do have direct evidence of somebody else that was driving the vehicle. And that comes from my client testifying that Caesar, even though not there, was the driver of the vehicle that day. So there was kind of a two-part to my closing. Normally it's, in most trials, it usually is just kind of the first part, relying on the state of the evidence that's insufficient. But here, just because we have direct evidence that we put on our own case, there's kind of like this two-component part to my closing.
It's fantastic. And I mean, you're trying to tell me you argue that a cop said something and it maybe wasn't the truth or his interpretation was wrong?
Right.
I love that. How long did the jury end up deliberating for?
They deliberated for like 3 or 4 days. It was like a holiday weekend too.
Oh shit!
Yeah, it was something ridiculous, and it was like a holiday weekend. I think it was like Labor Day. It was like it literally was like a week late. Like the verdict didn't come back for like a week. I had like literally was in court like working my other cases like just because like you just can't stop working.
And that's amazing.
They were out for a long time, and then
okay. Well, you get the drum roll. What was the verdict?
Not guilty.
Let's go.
It was awesome. Yeah, not guilty. I mean, could not believe it. I mean, I remember at that time, like I said, we had post bars. So for the verdict and for most of the trial, we had an audience. Actually, all criminal trials are public, so anybody can come in and watch as long as they're not causing disturbance. They'll probably get kicked out. But if anybody can come and watch. And for most of the trial, we had a pretty big audience just because we had interns that wanted to see what a trial looked like. Usually trials don't have an audience. Maybe there'll be some family members, some friends of, or maybe family of the alleged victims. But this case had a big audience, so it was kind of a um, big thing. Also, not only from my office, but from the DA's office. Everybody was kind of invested, especially the DA's thinking this is a slam dunk. What's going on? Why are jurors deliberating so long? So we kind of have this packed house when we get the verdict, and then sure enough, verdicts of not guilty on count 1 and 2, and it was stunning. I mean, when you hear those words, it's like chills, like run through. Your hair stands up. I mean, it's just you just can't believe it. And I even had to tell my intern, I'm like, did I just hear not guilty? And he's like, yeah, that's not guilty, and it's a full acquittal. Client walks away, no problem, no conviction.
I love that case because, honestly, I've had that set of circumstances with a client too, where, you do an interpretation or analysis of the case and, just given everything that an individual is facing, it might actually be in their best interest to plea. And it's through their desires, their convictions that no matter what the risk is, they want to exercise their right. And it takes an amazing person and a humble person to be able to get past whatever their own personal views may be to give that client that day in court and at the end of the day be proven wrong. I love those circumstances and I wish nothing more than them because we can take any case to trial. It doesn't affect us in any type of way. But when, clients are looking down the barrel of the gun of the government and are looking at horrible circumstances, it is a very powerful thing to say, no, take this to the box. And so I love that for you. And that's a great segue into the last question that I always ask our guests. And that is, Carlos, after taking this matter to the box, what would you say is the most significant thing that you learned?
I just think that this case was a great example of things aren't always as they seem, right? The things in the report don't dictate what happened on that day. I think oftentimes it's easy to get caught into like the four corners of that piece of paper. That police report says this, this, and this, and it's easy to see like, oh, okay, this is what happened. This case doesn't look good. I think this was a good check on like, look, you need to litigate cases. You need to see what the evidence actually looks like when witnesses come in and testify. And yeah, like you said, take it to the box, right? You need to go and argue that, look, the facts aren't as they seem. The facts aren't as they're written in the police report because, of different things that happen. And I think that's a great example. And I think other attorneys really should practice is of just litigating more. And the more you litigate, since then I've done more trials, I've done more hearings where, you challenge it, say, no, this did not happen as you say it did. And then it comes out at trial and that's the case, right? Something different happens. Some different word comes out, some different explanation of what happened comes out. And that's not what was reported on the day of the incident. And what was reported is the basis for the charges brought against your client. So I think that was the biggest thing. Everyone, like I remember I went through 3 judges. At the time, you had to go through the misdemeanor arraignment judge before going to the presiding judge, before getting sent to a trial judge. And every judge at every stop was like, look, what is going on? This is a slam dunk loser. Mr. Cerna, why are you taking this case to trial? Presiding was like, why are we wasting a courtroom for a misdemeanor trial that it's a high blood alcohol level, high, just a straight loser. Why are we taking this to trial? And, one of the reasons is just because, the things in the report aren't always as they seem.
It's because it's our right. That's why, Carlos. Thank you so much for taking this case to the box. Thank you so much for joining us on Members of the Jury and educating us and showing us what it is and the power of dedication, strategic thinking, and utilizing your right to due process. So thank you so much for coming on and sharing your story with us. Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury.
If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. The information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.
Free audio post-production by alphonic.com.